Hello friends, this is my long video on annulment, judicial separation and divorce. In today's day and time when marriages are going through several transitions and the man and wife equation is changing because of the empowerment of women, it is often seen that there is trouble in marriage. It is not an issue where one person is very bad and the other is very good. It is an issue of inability to find that balance or strike that balance which is required for pulling a marriage in a long time. What is happening is that within few months of marriage, when adjustment is at its most difficult peak, people are deciding to separate. There are several ways of separating. One is judicial separation, one is annulment of marriage, and the most common form is divorce. Annulment of marriage and divorce brings in a complete severance of the relationship of man and wife. But judicial separation is a concept where cohabitation is not compulsory after a decree or an order of judicial separation is passed by the court, but the relationship of marriage continues between the husband and wife. Except for cohabitation, all other conditions and rights and liabilities of being married continue. For example, the husband will be liable to pay for maintenance of the wife and children. The custody matters will be decided as to who will retain custody of the children during this judicial separation period, and the order may be passed at any time in a marriage. In a process for judicial separation, what is good is that the couple who may have proceeded to court in the heat of a moment or in the heat of arguments do get a time to think about the end of the relationships and to what end they are trying to take the marriage to. If they, after a certain period, if they still feel that they want to go ahead with a divorce, they may go ahead. But if sometimes when they think calmly and stay separately and think again, they may feel that they can give their marriage another chance. Therefore, judicial separation is a novel concept which helps people to go back to their married life if they feel that they have acted in haste. The next concept in marriage severance is annulment of marriage. Now, what is annulment of marriage? Annulment of marriage is not divorce. Annulment means that a marriage will be declared null and void. But most importantly, the conditions and the requirements for annulment of marriage are very, very strict. It is provided in the Hindu Marriage Act and in the Special Marriage Act. However, nobody can go in for annulment of marriage simply on the ground that their marriage is not working out. The grounds for annulment of marriage are very, very strict. It could be a marriage based on fraud or force. It could be a marriage where one of the spouse already has another living spouse. There could be a situation where the person has gone into a different relationship, physical relationship, while continuing in the marriage. So these are only some of the criteria in which annulment could be applied for. Annulment is a rare concept in our country, but it is not that it has never been granted. The last and most common form of severance of marriage is divorce. Divorce also, under the laws, has some categories or requirements which have to be fulfilled before one spouse can apply to court for divorce. This is when they are filing the divorce petition singularly. This is not a case of divorce by mutual consent. I shall discuss divorce by mutual consent on another occasion. In this case, I am only discussing divorce which may be contested and in which only one spouse is filing for divorce. There are 2 or 3 grounds on which divorce can be applied for. One is ground of cruelty. One is ground of bigamy, where the person has another spouse before or after being married to the person who is applying for divorce. There could be another case where the spouse may be of unsound mind or is mentally unstable from time to time. So there are several grounds on which divorce is taking place in today's day and world. It is very true that the percentage of people applying for divorce has gone up simply because the stigma on divorce is slowly being erased from the Indian society. However, there is also a situation where people are giving up on their marriage very fast. So, divorce, though available as a mode of severing the marriage, should not be misused. For example, when people have children involved in marriage, young children who are not yet in a stage where they can look after themselves, and if the spouse is in a very monetarily unstable situation, a divorce is forced upon the spouse and they are forced to take a divorce because somebody is torturing them. In these cases, divorce is a misused concept. However, that does not mean that a person cannot apply before the court to get freedom from a marriage which is otherwise not working out. Though in earlier days, people had to strictly prove the case in terms of the grounds provided in the law, but in today's day and age, the Supreme Court of India has also granted divorce to people who have been living separately for years together and fighting divorce through the trial court and the appeal court down below. They have actually felt that if a marriage has not been consummated and they have not cohabited for so long a period of time, then that marriage is emotionally dead, and simply because the grounds could not be proved, the divorce should not be denied to the parties. In such cases, the Supreme Court has also granted divorce to parties who have not been able to prove their case in courts below. There is no specific time period when a person can apply for divorce. There is a time which is laid down in the law, but in very, very grave cases, if there has been immense physical torture for dowry, or in that line something, there has been domestic violence, then people can apply for divorce even within 3 months of marriage or 2 months of marriage. In some cases, where dowry is concerned, people do not even take the girl home. These are the realities which we do not face probably in urban areas, but in rural areas there are several issues which crop up which are very, very devastating. So in such cases, the divorce can be granted even if the time period and the requirements cannot be forcefully placed before the court. However, there is an issue of where to file the divorce for. There are certain courts which have jurisdiction, and these are the civil courts. Divorce cannot be filed before a criminal court. Divorce can be filed where the marriage has taken place, a court having jurisdiction over that place, or where the girl is presently staying, or where she had lived with her husband. In any of the 3 places, she can file the divorce. So, divorce is a long-term process if it is contested. So, if people can come to a settlement in case of a disturbed marriage and go in for divorce by mutual consent, it is always a better option. Otherwise, the whole process of litigation can be very, very stressful for the parties. And I am not talking only about the girl. Sometimes even men are put in very, very difficult situation. They work in some place, they live in another place, and the case may have been filed in an absolutely another city or town, and it is difficult to go and locate lawyers and proceed with the litigation. So in order to not to get into these kinds of physical and logistical difficulties, if the parties can sit across, talk to each other, and proceed for divorce on mutual consent, it is the best for everybody. I hope I have been able to give a brief overview of the whole process, and it will help people who are struggling in this area. Thank you.